Leo, cover.
Yes, sir.
That's you, sir. Time's come here. I think we got you ready to go. We're going to be picking a jury this afternoon. And as you know, you're charged with the state jail felony of publishing or threatening to publish intimate visual matter.
Hold up publishing intimate images without consent. That's not just messy, it's a serious felony in Texas. Let's see how deep this case goes.
In 2231, that's a state jail felony, and also in 23 CR 2232 is another state jail felony of theft of property. And each of these are alleged to have occurred on or about July 30th, 2023 in Jefferson County, Texas. And it looks like the victim is, or the complainant is the same person. And you're still insisting on representing yourself?
Yes, sir.
Okay.
Yep, representing himself, bold move. Less than 1% of defendants do this, and it rarely ends well. Would you ever take that risk?
We're going to have a standby counsel to help you, John West. But you can take care of what you want to do on your own. You just have to. That's John. He was a competent lawyer. He's going to be there for you. If you ever need to ask him something, you don't have to.
You don't have to.
The law says they're in the bullpen, ready to come out to help you if you need it. This is your life, and you've made, bless you, you've made decisions here on how to represent yourself. And very seldom does this happen, that a defendant represents themselves, but it can under the law.
Here's the twist. If you act as your own attorney, you must know the law. There's no "I didn't know" defense, not even for court procedure.
And the important thing is that you're completely and totally appreciating and understanding that you're held accountable, like lawyers are, to know the rules of evidence, the Code of Criminal Procedure, and the Penal Code. Those are the basic codification of laws that come into play in cases in this court, and these are where the crimes come out of. The Penal Code, Code of Criminal Procedure, dictates the way proceedings work through the process from the beginning to end, and then the rules of evidence, or the methodology of how things are presented in court. I was on the Rules of Evidence Committee that wrote these, so I'm intimately familiar and sensitive about the way this is going to follow. What we're going to do is order a jury, and we will select a jury, voir dire the jury, and you're certainly going to have an opportunity after the state goes. I go first and do an overall general set of instructions. Then the state gets to ask questions of the jury, and then you can, if you want. And then that's all for the purposes of selecting a jury, deciding which strikes you're going to use. Then at the end of the voir dire, each party gets to select their select their strikes and make their strikes. And then the first 12 jurors and alternates who have not been struck will be seated right over there. And then we will swear them in and begin the presentation of the evidence with the court's reading of the rules and the instructions to the jury. Then each party gets to make opening statements, and then the state calls witnesses. You get to cross-examine witnesses. At some point in time, the state will say they rest. At that time, you may or may not call witnesses. That's your call. You can take the stand as well. But at the end of the...
And here it comes. Flips the script, claiming he hasn't even been properly arraigned yet. Is this a misunderstanding or a meltdown?
Presentation of the evidence. I will read the jury charge. The parties will make the final arguments. and then jury will go back and deliberate on a verdict. Do you understand where we're going to proceed?
No, I don't, because I haven't been arraigned. This is my first time in court. I haven't asked if I'm guilty, I'm not guilty. I haven't been read the charges. I haven't had a motion hearing on any of my motions. I haven't had you order whether I could get subpoenas for my witnesses. I haven't had discovery, which I've asked for from you. I've filed with the court clerk. I've sent the assistant district attorney the letters for it. I've filed for 2 writs of habeas corpus that hadn't been heard. I filed motions to quash the indictments that hadn't been heard. I got a motion right here to dismiss the prosecution that hadn't been heard.
You've never
You
seen it?
haven't held any of my motions at all.
All right.
And here are the rules that you helped write.
Sir,
It says you should.
when I speak, you can stop,
Okay.
because we can't speak over each other.
Thank you.
She's got to take everything down.
All right.
Follow those rules and don't be rude.
Okay.
Can you do that?
Yes.
All right. First thing, I thought we went over this indictment. No judge has ever gone over this indictment, a JP or anybody
Yes.
else? Do you have a copy of the indictment?
No,
Of the
I don't.
indictments? You've never
I had
had a copy of the
It
indictment?
was on the kiosk.
Okay.
It's on the kiosk
All right.
at the jail.
All right. 23 CR 2231 alleges that, in summary, that on or about July 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of publishing or threatening to publish intimate visual matter. This states that with the intent to harm the complainant and without the effective consent of the complainant, you disclosed visual material.
That's count 1, and it's brutal. Revenge porn laws are clear in Texas, and if proven, this charge could land him behind bars for 2 years.
Namely an electronic image depicting the complainant with her private portions exposed, and at the time of the disclosure, you knew or had reason to believe that it was created under circumstances in which the complainant had a reasonable expectation of privacy, and that the visual matter would remain private. And the disclosure of the visual matter caused harm to the complainant, namely the image was posted on a public social media platform, and the disclosure of the visual material revealed the identity of the complainant, and namely that image revealed the face of the complainant and her name against the peace and dignity of the state, signed by the foreman of the grand jury. If convicted of this offense, you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with now in the punishment range?
Yes, I do.
In 23 CR 2232, this indictment handed up also on December 13th, 2023, goes on to allege that also on or about July 30th, 2023, in Jefferson County, Texas, you committed the state jail felony of theft. You unlawfully appropriated property, namely jewelry and clothes and tools of a value of $2,500 or more, but less than $30,000 from the complainant, who is the same complainant as in the previous indictment we read with you.
To separate felonies. Same day, same alleged victim. This is shaping up to be a tangled case of stolen property and digital betrayal.
I read over with you, and she was the owner of that property, and without her effective consent of that owner and with the intent to deprive the owner of the property, you committed this theft against the peace and dignity of the state, signed by the foreman of the grand jury. As well, in this case, a state jail felony carries with it no less than 180 days, up to 2 years in the state jail. A fine up to $10,000 can be assessed. Do you understand what you're charged with in that
Yes,
case?
sir, I do.
Okay. Well, I thought Mr. Kimler was working with you before.
No, sir, and I don't know how Kimber ever got a retained lawyer, because I did not retain him.
Wait.
I've never signed anything to
he's-
retain him.
Okay.
Ever, never. My signature's nowhere. I've never retained him, I've never hired him. And I don't know how he got on my case.
Wait, so the defendant didn't hire the lawyer, who filed motions on his behalf. This kind of confusion could derail the entire process.
did he ever come to talk to you at all?
One time,
Sir?
one time.
Do you know how that happened?
Yeah, we have jail calls where defendant's acknowledging Mr. Kimmler, his attorney. He may not be very happy with him at the time, but he's on jail calls acknowledging that. I mean, he's up there sort of telling you this. Well,
Thank you. He gets to speak. You don't interrupt, Mr. Interrupter.
now I believe I think that was some of the confusion with the motions on it because Mr. Kimmler was representing the court. Obviously, is not going to respond to these motions when Mr. Kimmler's representing him while he's doing it pro se. So then,
Yeah, I to this day, I don't understand. We've had this before, and I don't understand how that all happened, how that all occurred. Because, read this. This is out of the file. Read that, sir.
It says, "Dear Judge Seasons, please be advised that I have been retained to represent the above referenced defendant on the docket call number 7. Please set the case as soon as filed for docket.